Hello and welcome again to this webinar. The focus of today's session is legal implementation of limited risk arrangements in transfer pricing. My name is Paul Sutton and I'm one of the co-founders at LCN Legal. From my perspective, I would say that limited risk arrangements is probably the most tricky transaction type when it comes to legal implementation of TP policies. And in terms of the issues and possibly the errors that we come across when we're reviewing agreements in this category, the two main errors that we come across are, number one, the transaction is not properly delineated from the first place from a legal perspective, and number two, a mismatch between what is stated in the TP policies and the terms of the agreement. So really that's what we're aiming to air on this session. So what we're going to cover is, well, what are limited risk arrangements and do they exist in third-party commercial arrangements? We'll start from the end in mind, so very much our philosophy at LCN Legal as to how we approach agreements generally. We'll look at the 4+1 key areas, as we refer to them, of intercompany agreements as they apply to limited risk type structures. And then we'll come back to these key areas of delineation, risk, and talk about pricing clauses for target margins. And then finally, we'll wrap up and recap on the 10 commandments of intercompany agreements. So just a couple of housekeeping issues. First of all, we are recording this session, so hopefully we'll be able to share that recording sometime next week, and we'll share it together with the slides. The other thing is that if you do have questions or comments as we go through, please do use the chat function. If I can, I will pick them up as we go along. If not, I'll do my very best to pick them up towards the end of this session. And then finally, we don't claim to be the font of all information and all knowledge about intercompany agreements. It is our dedicated focus, but we're always welcome to hear different views and opinions. So who are we at LCN Legal? So we're a law firm. We specialize in intercompany agreements for transfer pricing. My personal background is that I started off as a corporate lawyer, and then I joined KPMG's law firm in the UK back in 2001, and started working alongside the tax, international tax and transfer pricing teams there. And really that was my entry into the world of transfer pricing. And it's been something that I've been doing more and more since then. And at LCN Legal, this is our dedicated focus. So although we happen to be based in the UK, we take a global approach to intercompany agreements. And a lot of the work that we do has no connection with the UK at all. So we support TP advisors and multinational groups across the world. We don't advise on tax or transfer pricing or benchmarking or functional analysis or economic analysis. So we don't cross over in terms of the work that traditional transfer pricing advisors would do. So what are limited risk arrangements? So, well, there's certainly no legal definition of a limited risk structure or a limited risk distributor. There's no transfer pricing definition either. It's not a term of art that is defined in the OECD's TP guidelines. So what is it? Well, in general, it refers to a controlled transaction. In other words, a transaction between related parties where one party, let's say party A, is intended to control and assume certain risks and has the capacity to do so. Party B is not intended to assume those risks, but is the counterparty to that transaction. And the compensation attributable to Party B is reduced accordingly. So generally speaking, this requires a contractual allocation of risk in order for it to be implemented. So the classic example, as already mentioned, would be a limited risk distributor. And when we review TP policies, and we review a lot of them in our role, so the kind of statements that we tend to see in TP policies and documents regarding limited risk distributors are things like the distributor is not intended to carry inventory risk or product liability risk or credit risks or market risks generally, and is guaranteed a routine return, and often that's based on a target margin. So that's the kind of arrangement that we're talking about here. So sometimes when this subject, limited risk distributors and limited risk arrangements, comes up, particularly amongst TP advisors, we hear the view that limited risk arrangements only exist within related parties or in the context of related parties and are not a feature of third-party commercial behavior. I have to say that that is wrong, and we can confidently say that because, as I mentioned before, both I and all the other lawyers at LCN Legal, our backgrounds are corporate lawyers, commercial lawyers, advising on third-party transactions. And so I personally have negotiated a lot of commission arrangements, management agreements, all these kind of things. And there are plenty of examples in third-party life where the contractual allocation of risk is actually a key function of it or has a key impact on pricing. So just to give a couple of examples, first one, and probably the simplest, most obvious one, is commercial agents. So if you imagine that you were a business and you were appointing a commercial agent to create sales for you, then it could be on a pure commission basis. In other words, the agent eats what he or she kills and only gets paid at a certain percentage commission rate if a sale is actually made, or maybe even if it's only if the payment is received from the third-party customer. A variant of that would be where the agent is guaranteed a minimum level of commission. Maybe that's on a monthly basis. Maybe that's even akin to a salary type return for that agent. And of course, the presence of that guaranteed commission level is going to have a huge influence on the percentage that is agreed for commission on sales. So that limitation of risk or that reduction in the exposure of the agent to that market risk has a very material impact on the commission rate. Another example in third-party arrangements would be hotel management agreements. So that would be an agreement between the owner, so the landowner in relation to a hotel, the owner of the actual building and surrounding lands on the one hand, and the operator or the proposed operator of the hotel on the other. So that operator may be one of the hotel chains that we're all familiar with. So depending on the economic conditions, it's actually not uncommon for the hotel operator to guarantee a certain level of return to the property owner, and that may be expressed as a margin or net profit or something like that. So that's another example of a guaranteed return which has the effect of limiting risk. I won't go through all the examples but on this slide, but I'll just touch on the next one, which is salaried partners within professional firms. So if you're familiar with that kind of arrangement, a salaried partner is someone who is held out to the outside world as a partner, is represented to be a partner, and that may mean, depending on the type of partnership, that salaried partner may have unlimited liability for the debts and obligations of the partnership. However, as a matter of the internal arrangement within the partnership, the salaried partner actually receives a monthly or annual guaranteed amount, so it's a fixed amount akin to a salary, and he or she is indemnified in the partnership agreement against third-party claims, and probably that salary partner will not be required to make an equity contribution or capital contribution. So that's another example of a de-risked arrangement, which therefore carries a different return compared to an equity partner. So all of those maybe it's interesting by way of context. It's probably not that useful for TP practitioners in terms of benchmarking because it's probably difficult to get usable data regarding those arrangements, but I just thought it was important to put that in context. So starting with the end in mind, what do you mean here? I mean, it's, as I mentioned before, this is fundamental to our philosophy in terms of what is our task here. So from our perspective at LCN Legal, the end result that we really care about here is not just doing our initial job of drafting an intercompany agreement and getting it signed up. That's the start of the process. The ends that we really care about is that point in time, which is 3, 4, 5, 6 or more years after the relevant period, when the TP audit or the tax audit actually happens. And it's that point that the taxpayer obviously needs to defend the transfer pricing positions by reference to the relevant evidence. And of course, as we now know, the legal agreements in place during the relevant period is a key part of that evidence. So you could say that the watchword now within the tax and transfer pricing industry generally, it's all about substance, it's all about evidence. And we're a world away from the environment 15 or 20 years ago when it would be sufficient to have a TP report, but where there was no substance behind it. So that means it's all about audit defense. And in terms of the role of intercompany agreements and what that means as a contributor to that audit defense, it means what? Well, the agreements need to be contemporaneous. In other words, prepared in advance of the relevant controlled transactions and not after the event. And one of the reasons for that we'll come on to is you can't backdate the allocation of risk. Obviously, the point number 2, the agreements need to be aligned with the TP policies, but also with the other needs of the wider needs of the relevant group. So that includes customs considerations, VAT, and GST considerations. It means the agreements must be archived, so kept in a central archive and available at short notice. Many of you will have come across the recent decision of the Spanish National Court, which disallowed a deduction for fees for service charges. And in that case, the taxpayer claimed that agreements had been put in place but was unable to find them. And the taxpayer produced evidence by a so-called expert as to the nature of the services supplied, but that was in effect disregarded by the court. So it's critical for the agreements to be archived. And then finally, and importantly, it's no longer good enough for there to be solid TP policies, robust agreements. In addition, as shown by the Singapore Telecom case, or sorry, Singapore-Australia case, it's essential to document the commercial rationale for the arrangement so that the courts or the tax authorities are not having to make that up or reconstruct it for themselves. So for those of you who've attended previous webinars from us, we talk about 4 key areas of alignment between intercompany agreements and transfer pricing policies, and there's the 5th category of fitness for purpose. So I'm just going to go through this in detail. I can see that there's already a comment, limited risk. I believe the issue is not so much that the existence of such unrelated party legal agreements, but that typical databases of comparable company distributors do not make such distinction. Absolutely agree that. One would need to intensively research agreement databases to find limited risk clauses. Absolutely, that's definitely where things stand right now, as far as I understand it, in terms of availability of information. So going back to this slide, the 4 areas of alignment. Number 1 is delineation of the transaction. In other words, we're comparing the functions of the relevant entities as described in the TP policies with the key obligations in the agreements, and just making sure they match, because obviously a mismatch there suggests that something is going wrong already. Number 2, risk allocation. We'll come on to this separately because obviously this is inherent in this kind of transaction. It goes to the heart of what we're talking about here. Point number 3, we won't go into in any detail on this webinar, but alignment between agreements and TP policies about ownership of IP and intangibles is critical. We've all seen from recent cases such as Coca-Cola, what might happen or what can happen if there's misalignment there. Fourth area of alignment is pricing. So making sure that statements in the TP policies are actually implemented legally in the agreements. And we'll look at specific approaches to drafting of pricing clauses later. And then finally, as I mentioned, it's also important to make sure that the agreements are generally fit for purpose. That includes the basics like getting the parties right, signatures right, dating, the duration of the agreement is important, and making sure that there are no procedural provisions which are inappropriate and which don't reflect how the group works. So this is one reason why we generally say it's not helpful to use third-party agreements as the starting point for intercompany agreements, because they generally contain a whole load of provisions which are not appropriate and which are contradicted by the actual operation of the group. So this slide here is about that alignment area number one, so delineation of the transaction and what are the key operative provisions. The key thing that we see time and time again here in relation to limited risk arrangements and actually distribution arrangements generally is that the TP advisors haven't even considered the contractual structure of the group, and therefore they've actually failed to identify how the risks apply and play out in relation to the individual legal entities. So in other words, it's essential to actually understand what is the business model of the group in terms of how it interacts with third parties, and particularly with customers and suppliers. So in order to do that, number one, you need to understand that contractual model. That may involve looking at sample agreements with customers and suppliers. Sometimes it's obvious, and sometimes groups are absolutely crystal clear about this. Other times, especially as regards software and IT type services, in many cases we find that the client group actually doesn't know, can't give you a clear explanation. So you do need to dig a bit deeper and understand, well, what is actually happening contractually, what is actually the sale process, and which legal entity makes those sales. Item number two, regulatory issues. As we all know, where it's a regulated sector such as financial services or pharmaceuticals, there may be very hard-edged legal restrictions which require a particular entity to have the relevant regulatory permissions or approvals in order for it to be able to make supplies directly to third-party customers. So obviously where those regulatory issues apply, then they will trump pretty much everything else because they are a ticket to play in that market. So where that applies to the relevant group, then clearly you need to understand that, and that needs to be correctly understood in the TP analysis and also, of course, reflected in the agreements. Item number three, flow of physical goods, where the transaction type involves goods. So obviously, in many cases, the flow of physical goods may be different from the contractual chain of sale and purchases. For example, you may have direct delivery or direct fulfillment by the manufacturing entity to the third-party customer, whereas from a contractual perspective, there are other links in the chain. So clearly we need to understand that in terms of risks like inventory risk and so on. Sometimes it's necessary to really drill down into the flow of funds in terms of cash. And similarly, it may often be useful to look at the revenue recognition policies of the relevant entities to make sure that the picture that we're building from a TP perspective and a legal perspective makes sense in the context of the accounting policies of the group. And finally, I put functions in square brackets. The reason for that is, of course, it is critical, both from a legal perspective and from a transfer pricing perspective, to understand who does what in the group, so that the value contribution in the supply chain. The reason why I've put that in square brackets is that a functional analysis alone will never delineate a transaction. And that's because one given set of facts in terms of, for example, the role of a local sales entity may be consistent with a number of different legal scenarios as regards how the contractual chain works. And each of those different legal scenarios may imply a completely different risk profile for the individual legal entities concerned. So that's why it's at the end of this list. So let's move on from delineation and talk about risk. Obviously, alignment of risk as between TP policies and agreements is absolutely essential. I put on this slide here an extract from the OECD TP guidelines as regards to the steps for analyzing risk. And it's summarized very broadly on the right-hand side there. So identify risks, ascertain contractual allocation of risk, carry out functional analysis, check whether ICAs are consistent with conduct, check assumption of risk is consistent with control and financial capacity to bear it, and then pricing of transaction. Of course, this is very much the view or the recommendation for tax administrations as to how they will review transactions after the event with the benefit of hindsight. Our joint task as the legal advisors working alongside TP advisors, I would say, is much harder because it's about designing these structures in advance. So it's going hand in hand. The proposed TP policy is going hand in hand with the agreements and making sure that they work from a wider perspective. So that's what we're aiming for here. So let's talk about contractual risk allocation and what it actually means. And I put on this slide some examples of clauses that would typically be used or often be used in intercompany agreements and which would have the effects of allocating risk. And again, going back to that start with the end in mind slide, what we're aiming here is for the TP policies to be able to make statements which are then verifiable. So it's a bit like the process for writing a prospectus for an IPO, if you've ever been involved in that process. So as part of that process, the IPO prospectus will be drafted, and then a separate verification process will be carried out, which goes through each of the statements in the prospectus line by line and say, do we have evidence, which means that statement can be truthfully said, and who is taking responsibility for the accuracy of that statement. And it's exactly the same standards that we should be applying in relation to TP policies, so that when that point in the future comes, that each statement in the TP documentation as regards allocation of risk is backed up by appropriate clauses in the agreements or some other explanation. So taking the first one as an example, product liability risk. Let's say we have a local distributor which is selling it in its own markets, and let's say it's in the automotive sector. So if that local distributor is the one making the sales, then from the legal perspective, that distributor would be the first port of call for product liability claims in that market. So the default position from a legal perspective is that product liability risk would sit with that distributor, as opposed to the intra-group principal, which has been the supplier of those products in intra-group to the distributor. So in order to move that risk from the distributor to the principal, what do we need? Well, it's probably a clause like an indemnity, so a dollar for dollar indemnity, where the principal is basically saying to the distributor, don't worry if any product liability claims are made, because we will make you whole, we will pay you back on a pound for pound basis for any liabilities that you incur. And so that's the kind of clause that would need to be in there. Just to mention also that unfortunately you can't look at clauses in contracts in isolation. So you do need to read the agreements as a whole. And in particular, things like liability caps in intercompany agreements, exclusions of liability, those can have the effect of undermining other clauses. So for example, if you had that kind of dollar for dollar indemnity clause, but elsewhere in the agreement, it's stated that the liability of the principal is capped at a certain amount, then those two clauses would in effect neutralize each other, and it may be that the result is that you haven't actually backed off that risk up to the principal. Moving on to the next example here, inventory risk. So as many of you will know, there's actually a mini case study in the OECD TP guidelines. It was originally in the 2017 version, now reproduced in the 2022 version, which shows the effect of a single intercompany agreement clause on inventory risk. So what we're talking about here is the risk that a distributor may not be able to sell all of its stock of goods. And a buyback clause is simply a clause where the principal is saying to the distributor, please buy stocks of our products, but don't worry if you can't sell them all, because if you asked us to, we will buy back any unsold stock at cost. And as noted in that mini case study in the OECD guidelines, the effect of that clause is to move inventory risk from where it would sit by default, which is with the distributor, back up to the parent. So obviously that's a key thing to consider when you're reviewing or drafting TP policies. I won't go through all of those, all the examples on this slide. Just wanted to comment briefly on market risk. In other words, the risk of a downturn in demand for the ultimate product. What clause would you see in intercompany agreements dealing with that? Well, at one level, you could include a clause or a recital in the agreement saying the distributor is not intended to bear market risk, but actually that doesn't mean anything. It's hard to interpret that from a legal perspective. Actually, it tends to be that the treatment of market risk is in the guaranteed return, and we'll come on to that later in terms of drafting approaches there. So before we leave the issue of risk allocation, contractual allocation, I'd just like to emphasize the fact that it's important not to look at transfer pricing considerations in isolation, because there's a direct tension between stripping risk out of a distributor on the one hand, and on the other hand, giving the group the benefit of the ability to ring-fence risk within a particular legal entity. So what do I mean by that? So let's imagine that there's a group where there's the central entrepreneur, P, the principal. It has an LSE or local sales entity in a particular country, and that entity is making sales to customers in that market. So it's a very simple structure. And let's say that relevant market is considered to be high risk in terms of product liability claims. So if you leave the arrangement as a full risk distributor, so you don't try to back off product liability risk up to the principal, then that means that from an asset protection liability, asset protection point of view, the group could take the view that it is getting the benefit of the ring fencing of risk, so that if there were to be a catastrophic claim in that country, then worst case scenario, that local sales entity could be sacrificed, but the rest of the group could continue to operate. Whereas if a limited risk distribution arrangement were put in place which contains that kind of indemnity clause, whereby the principal would pick up that liability and would indemnify the LSE, then that would mean in an insolvent situation, the liquidators of the LSE may be able or may be obliged to actually enforce that clause against the principal. In other words, the group would lose the ability to ring-fence risks in that local legal entity. So this is a very generalized or simplistic discussion of this. The point here is just to flag the issue at this point to say, well, you can't have your cake and eat it. And it's important to look at risk allocation within transfer pricing policies on a holistic basis, on the basis that it may have an impact for non-TP issues. I can see that there's a question here, so thank you for that. When you get to pandemic risk, can you please elaborate why it is not necessarily a force majeure clause? This is a common one. We understand that it's not necessarily force majeure, but everyone is citing it as such. So thank you very much. That's a great question, and it's something that we see a lot of commentary, or have seen a lot of commentary in TP articles about. So when you think about it, what is pandemic risk? It can relate to a number of different matters. It may play out for a particular group as an impact on demand or ability to make sales, such as in the airline industry, or an inability to actually fulfill orders or something like that. The reason why I say that force majeure clauses are generally not helpful is a function of what a force majeure clause is actually intended to do. What they're intended to do is to say that when one party is prevented from performing an obligation due to acts of God or events outside its control, such as pandemic, then that party is relieved from its obligation to continue to perform the contract, and is excused from the obligation which would otherwise arise, which might be to pay damages. In other words, it takes the party which has been prevented from performing off the hook. What it doesn't do, it doesn't provide a mechanism for repricing transactions. So, for example, if you have a situation where there's a local distributor, it's guaranteed a certain target margin of 5%. Pandemic hits, and the group as a whole is under financial pressure, and it wants to, in effect, renegotiate those arrangements and reduce the margin that is being earned by that local distributor because the group as a whole is loss-making. The force majeure clause is not going to help there, because it doesn't give the principal in that arrangement a ground to terminate the agreement, and even if it did, termination of the agreement is not the objective here. And equally, it doesn't help the distributor. So if the distributor were to be prevented from performing, it may be able to rely on the force majeure clause to terminate the agreement, but that's like a turkey burning for Christmas. It means that distributor would remove its livelihood, its reason for existence. So generally speaking, force majeure clauses are actually not helpful at all. There's nothing wrong with including them, but they don't address the issue, which is adjustment or reallocation of risk, repricing of transactions to reflect economic conditions. And my opinion is very much in line with the OECD guidance on the TP aspects of COVID, which is what is required is a renegotiation of the arrangement. So just as maybe a commercial landlord with a retail tenant may have agreed a rent-free period during the pandemic because the landlord has an interest in maintaining that tenant in place for when it recovers. So that is a typical behavior of unconnected third-party businesses. Exactly the same applies within the group. So it's a matter of renegotiation and amendment of the agreement, not reliance on some automated contractual provision. Okay, so I'd like to move on and talk about pricing clauses and target margin arrangements. So the kind of scenario that I'm talking about here is the limited risk distributor type scenario. And maybe the benchmarking has suggested that the distributor should receive a target margin within the range of, let's say, 4% to 7%. The question is, well, how does that actually get implemented in the intercompany agreement? Broadly speaking, you've got two options here. Option one, you could refer to as just a framework agreement. So the ICA, the intercompany agreement, might express the intention of the parties for the distributor to receive a benchmarked margin. However, the pricing clause may be left vague. It may contain statements like the pricing of shipments will be agreed by the parties from time to time, or something vague like that. And there might be no legally binding true up or true down provision. In other words, if the results of the distributor for any financial period were beneath that target 4%, then the distributor would have no contractual right for a true up payment. So from a legal perspective, from a conceptual perspective, that's a possible approach. However, the impact is it's doubtful whether market risk has been allocated to the principal. You certainly can't point to the agreement as justification for that kind of statement. The related point is that the TP documents cannot truthfully say that the distributor has a guaranteed return, because that's just not true. So it's really questionable whether that kind of clause or that kind of drafting approach will then align with the TP policies. And this is within the context of the common sense approach that, or the common sense reality that risk only has a meaning if there's uncertainty. And uncertainty only exists in the future, not in the past. So just in the same way as you can't drive your car, have a crash, and then take out your accident insurance, you can't allocate risk after the event when the outcomes are unknown. And that's one of the points made in the OECD TP guidelines. So what might option two look like? Well, one approach is a contractual target margin. So that might mean that the agreement, the ICA, would actually specify the target margin with legal certainty. So it might actually state that range. So specify the 4% as the floor, specify the 7% as the ceiling, and would contain a contractual, legally binding true up or true down mechanism. That kind of arrangement, or within the context of that kind of arrangement, the agreements could still allow flexibility for pricing of individual shipments to be managed on a real-time basis, because generally speaking, when we're talking about shipment of goods or controlled transactions involving goods, the group will need to manage and flex its pricing during the course of the year so as to hit the target margin as closely as possible. So what's the impact of that approach? Well, I would say that from a legal perspective, from a commercial perspective, that means that market risk is contractually allocated to the principal. So providing that the principal has the financial standing to actually honour its financial obligations, it means that the distributor will earn its minimum guaranteed return irrespective of a downturn in the market. So that's the definition of market risk as far as I'm concerned. And so the TP documents can truthfully say that the distributor has a guaranteed return. So there may be variants around those two options, but I think this is something that we see over and over again, which is pricing clauses in distribution agreements which actually undermine as opposed to supporting the intentions or the stated intentions of the TP policies. So in the context of pricing clauses and particularly target margin arrangements, I'd just like to touch on some customs issues. Again, I'm not a specialist in customs duties. We don't advise on that or on TP, but it's something that we often come across when we're asked to create appropriate intercompany agreements. As I'm sure you all know, there's an inherent tension between TP issues on the one hand and customs issues on the other. And that's because if you look at a transaction from the perspective of the distributor, then a higher import price will imply lower profits for the distributor, therefore lower corporation tax, but higher customs duties. And on the other hand, a lower import price for the distributor implies higher profits and probably higher corporation tax, but lower customs duties. So that tension, that conflict exists at tax authority level and also at the taxpayer level. So what does that mean in terms of the design of intercompany agreements, and what do you need to think about as TP advisors when you're asked to review these arrangements? Two general points. Firstly, is just the interaction between the supply of goods and also the fees for services and royalties or license fees. So depending on the nature of those arrangements, those kind of additional fees payable by the distributor may become part of the dutiable price for customs purposes. So there may be some flexibility for tax planning around that. For example, use of exclusive distribution rights and things like that. But it really emphasizes the point that the customs analysis can be very sensitive to the drafting of each of the agreements and needs to be very carefully considered. Second general point relates to these true up or true down payments, which are inherent in target margin arrangements. So if we could consider that example where we have a limited risk distributor, there's a contractual range of target margin between 4% and 7%. Let's say the outcome for a particular financial period was a margin of 1%, so there's a 3% shortfall. How is that 3% true-up payment actually characterized? Is it some kind of market support payment? Is it a rebate of the price of the goods involved? Is it just a payment and its nature or character is not actually specified in the agreement? What is the appropriate description or the appropriate approach? At this point, all I can say is it's very much fact dependent. It requires a holistic view, and certainly it needs careful consideration. My understanding from the customs advisors that we've worked alongside is that in some countries, including the US, as I understand it, it is actually possible to get a retrospective rebate of customs duties, provided that true-up payment is structured as a rebate of the price of goods. So that's where it exists and where it is possible can be very significant from a financial perspective. So that's certainly something that needs to be looked at very closely. And as we always say, intercompany agreements need to be prepared from a holistic perspective. So it's not just TP, it's not just customs and VAT, it's also asset protection, IP protection, management of data privacy and so on. So let me just pause and ask if there are any other questions or comments at this point. If not, then I'd just like to end by recapping on the 10 commandments as we refer to them. So the 10 basic principles for intercompany agreements. I can see a question there, so thank you for that. You're defining market risk in such a way to justify a target operating margin. Third-party distributor agreements may so insulate risk such that the distributor has a fixed gross margin, but the idea of pegging an operating margin strikes many of us as something that is not observed in commercial practice. Any third-party contracts to the contrary. Yeah, so that goes back to the example of third-party arrangements. So such as hotel management contracts. As already mentioned, unfortunately, I think it's very difficult to get statistical information on that. I don't know in terms of the definition of market risk, I guess the question is how else is it possible to say that the distributor does not bear the risk of a downturn in demand? So I'm not saying that net margin is the only way to go. From a legal perspective, we'd be equally comfortable documenting gross margin arrangements. All we're saying is that where the transfer pricing policies contain very specific terms regarding the outcomes, the guaranteed outcomes for the distributor, and the fact that the distributor or the allegation, the claim that the distributor is not exposed to risks of downturn in demands, that needs to be backed up in legal reality in some form. So there needs to be an operative clause which deals with that. So let me go through this list and by way of recap. So these points apply to limited risk arrangements as much as they do to any other transaction type. So point number one, agreements need to be clear and unambiguous. As I mentioned, perhaps 10 years ago, 15 years ago, the prevailing wisdom within the tax world is, well, let's just go through the motions of the agreement. Let's just have something so we can say there is an agreement, but let's keep it all so vague that we can never get it wrong. I think it's clear from not just case law, but also from local transfer pricing guidance, such as in Austria and other places, that no longer works. So it needs to be a genuine agreement with genuine substance, which means it needs to be clear and unambiguous. Point number two, as mentioned before, the agreements need to be as short as possible. Why is that? It's because the agreements need to be reviewed and approved by a number of stakeholders. And the longer the agreement is, the more likely it is that no one will read them, and it will contain provisions which are incorrect, inappropriate. Number three, the agreements need to be aligned with the contracting and financing model and the legal environment of the group. Otherwise, they're just a work of fiction. Item number four, as we've discussed, they need to be aligned with TP policies. And we mentioned the four main areas, namely the functions, allocation of risk, ownership of IP and intangibles, and pricing. Number five, the agreements need to be aligned with the other needs of the group. So that includes customs, VAT, withholding tax, asset protection, IP management, IP enforcement, and so on. Item number six, aligned with directors' duties. So this is what I call the golden rule for intercompany agreements. So intercompany agreements are genuine agreements. They're not some kind of fiction. And therefore, the golden rule is whenever you're considering the design of an intercompany transaction, you need to put yourself in the position of a director of that one end of the transaction, in fact, at both ends of the transaction, and say, is this an arrangement that you would actually put your name to? Is this consistent with your legal duties to safeguard that legal entity's employees, directors, manage liquidity risks, or is that going to expose you to risks of personal liability for breach of duty? So it needs to make sense from a commercial perspective. Item number seven, the agreements should be concluded in advance. I'm well aware that many groups are playing catch up in relation to intercompany agreements. So the reality is that to the extent that there are gaps, inconsistencies, they may need to be addressed they will need to be addressed, and you may need to consider whether it's possible or to what extent it's possible to backdate the economic effect of them. But irrespective of that, the sooner you plug the gap, the sooner you fix the hole, the better. 8, documented commercial rationale. So as mentioned above, it's really important, especially with more complex and counterintuitive arrangements, to explain why it was considered appropriate from a commercial rationale perspective to put in place this arrangement. And that's simply because by the time the tax audit comes, the relevant people may not be around anymore, and it's a fundamental part of the paper trail. Number 9, as mentioned, the agreements need to be stored in a comprehensive central archive which can be accessed quickly. It's no good having produced agreements if you can't find them. And 10, obviously, creating intercompany agreements is not a one-time exercise. The agreements need to be regularly reviewed and maintained, not just to reflect updates in the transfer pricing policies, but also to reflect changes in the group structure, acquisitions, disposals, legal entity reduction or rationalization projects, new business lines, and so on. So that concludes this webinar. Thank you very much for joining. If you do have any questions, we're always really happy to discuss scenarios on a no-names basis. We're always very happy to be to act as sounding boards in bouncing off potential legal approaches to the arrangement. So please do feel free to reach out to any one of the members of our teams. And thank you very much again. I look forward to catching up with you soon. Thank you.